What's up, everybody? Welcome back to Kohberger. I am fascinated with the battle back and forth about this alibi defense. What's the state so worried about? Why are they fighting it so hard? What problems do they have with Brian Kohberger's alibi this time? Why does Brian Kohberger continue to say he's going to update and add to this alibi? Is he messing with the state? We're going to break it down. We're going to answer your questions. We're going to read the state's response and see what we think happens from here as far as Brian Kohberger's alibi, how it's going to come out at trial, and whether or not it's legit. So sit back, hit that like button, and let's get into it. So here you have it, the response to the notice of defendant's supplemental response to the state's alibi demand. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following initial response to the notice of defendant's supplemental response to state's alibi demand filed herein on April 17th, 2024. At the outset, the state incorporates by reference as if fully set forth at this point those portions of the state's July 27th, 2023, about a year ago, the motion to compel notice of defense's alibi or alternatively to bar certain evidence. To the extent that it relates to the adequacy and timeliness of the defendant's alibi notice, that's just them protecting their arguments that they had in the past and reiterating them now. Nothing is going to change based off those prior arguments, in my opinion. The state respectfully submits that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19519, which provides that the defense shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Emphasis added. So they quote the statute. This stuff is what lawyers argue about, right? There's a word that says the specific place. So therefore, regardless, unless the defendant gives a specific address at a specific time or a specific name with a specific address and phone number, you can say it wasn't specific enough because the statute clearly says the word specific. The defendant's April 17th, 2024 submission minimally adds to the alibi notice dated July 24th, 2023. The defendant states that he was driving around during the early morning hours of November 13th, 2022, which we already knew, and drove, here's the additional part, throughout the area of Pullman, Washington, west of Moscow, Idaho, including Wawawai Park. With the exception of the reference to Wawawai Park, which is new, the defendant is offering nothing new to his initial alibi that he was simply driving around during the morning hours of November 13th, 2022. If I'm the defense and I'm reading this, I'm like, man, we've really got the state in a blender. Like their mind is twisted in a pretzel. We added something and they're complaining we didn't add enough. They keep complaining back to our old alibi. What are they so worried about? What are they so worried about? Are they worried that there's some witness that exists out there that the defense hasn't found? And if they find them now, they're going to argue that person should be barred because of the restraints on an alibi? Because they're not. I'll just tell you, if some McDonald's employee comes out and says, yeah, you know what? This guy was parked across the street in that park, laying on the top of his car looking at the stars, and I saw him, and we didn't know that person existed before a week before the trial, I would be shocked if the court struck that witness, if they found him to be reliable. How do they know that witness exists? Maybe that witness never came forward until a week before the trial. How do you find that person? The point is, you got to provide what you know so it's not a trial by ambush. And if, as soon as something like this would pop up, the defense brought it to the court's attention and the state's attention, the state's going to have a hard time getting that struck. If there was no reasonable way for them to find this information and they found it later, we're just going to throw a guy in jail because, you should have found the McDonald's employee that you didn't know before. Technically, maybe that could happen, but I would be shocked. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho, during the early morning hours of November 13, 2022. In fact, the defendant's travels during that time are described in the original probable cause affidavit supporting the criminal complaint in this case. And we know, like a lot of cases in this case, the defense is using some of the same facts the state's using and try to fit them into their theory. That's usually a good way to make an argument. It doesn't always win. But if you guys can agree on the facts, but say they mean two different things, the jury's got something to determine. As to the defendant's reference to potential testimony about the location of the defendant's cell phone on the morning of November 13th, 2022, this information does not rise to the level of an alibi. At the time of the homicides, because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicide. So he's saying this ain't good enough because the cell phone evidence is not evidence, it's a lack of evidence. And he lets us know at least a little bit about what the state's going to argue and what their evidence is going to be. Not that the cell phone was turned off necessarily. He doesn't say that here. I've heard a lot of reports and people saying that. But instead, the cell phone was not reporting for a certain chunk of time. Was he driving in areas where the cell phone doesn't report? Is he going to have somebody testify that I'm sure I'm pronouncing that wrong, that park has areas where the cell phone doesn't report? Is that what his expert's going to testify to? Maybe. But the state is saying it can't be an alibi if it doesn't specifically state where you were at the time of the crime and addresses and names and phone numbers of witnesses that can testify to that. It is the state's position that the defendant's continued failure to adequately comply with Idaho Code 19519 does not trigger a response under Idaho Code 19519-2. If the court deems the defendant's supplemental response to be in compliance with the requirement of Idaho Code 19519, the state requests additional time pursuant to Idaho Code 19519-5 to prepare a list of witnesses to establish the defendant's presence at the scene of the homicides. As to witnesses to rebut a claim of alibi, the defendant's failure to adequately comply with Idaho Code 19519 means the state does not know what specific assertions it needs to rebut. To me, these are kind of semantics arguments by the state. Why not just provide the witnesses? If you can prove he wasn't out driving at night during that time, prove it. Your cell phone expert, any witnesses to the scene of the crime, any witnesses that saw him, video evidence that you have him driving around this area with the car where you plotted the points versus being in rural areas far away from the crime scene. Provide it. But they're making the judge make a call first. Which, in this case, if I'm the judge, I'll say, yeah, that's his alibi defense. Either he or his expert, or maybe your expert, is going to testify to things that they're going to use. So provide your response. That's what I would think. I don't think the court's going to say that's not an alibi, but maybe he will if it's not specific enough. If the court allows the defense to offer further witnesses or information regarding alibi, which the state opposes as described below, and bring it into compliance with Idaho Code 19519, the state will then respond accordingly pursuant to Idaho Code 19519-2. So what's funny about that is even the state is kind of agreeing that this is not cut off. We have not reached the end of the line still. Remember the first time we read this and I said, this could last forever and ever and ever, amen. Even the state is understanding here with the statement that the judge could allow further witnesses or further information. Now, on the other side, this could just be the state being confident, saying, we know there's nothing else. We know you don't have the goods. We know you don't have any witnesses. We know you don't have any actual evidence. So judge, go ahead, tell them to provide more because they can't. But they're also arguing, cut it off. Here's the date, nothing more. It has now been approximately 11 months since the state filed this request for discovery, disclosure, and alibi demand. On May 23rd, 2023, and almost a year and a half since the homicides occurred, the defendant has been given more time than he is legally entitled in order to provide his alibi. The state is substantially prejudiced and compromised in its ability to investigate and respond to new and additional alibi-related disclosures. It's like, if you have the evidence to rebut any alibi, it shouldn't be that hard. Provide it. But also, how are you prejudiced? Explain to me how you're prejudiced. Because it's not like Judge. We've seen him. If there's any hint of prejudice and, Kohberger provides something that the state's like, oh, no, Judge, we need a year to rebut this. The judge is probably going to give him what is necessary. I don't think he'd give him a year. Of course, that's unreasonable. But he would give him a reasonable amount of time to rebut it, to deal with it, to scrutinize it. And I think it's a fair question if they want to say something like, what took you so long to give us this information, defense? And if the defense was sitting on something or playing games or being coy or hiding the ball, then maybe this judge would strike something. And then maybe Kohberger's got a ineffective assistance of counsel if they just blow it and they don't provide something that the rules legally say they have to. But if the defense just finds out about it tomorrow and they immediately tell the state and the judge, do you think that that information should not come in? If it proves an alibi that Kohberger was not at the scene, isn't that what we all know? If I was a victim in the case or victim's family, I would want to know that. I don't want a young person to go to prison for the rest of his life if there's a legitimate alibi. Now, of course, legitimate alibi is something I can put in quotes because some people say, oh, please, where did this person come from? Or they doctored that video. And sure, they could create more questions than answers. And that's a possibility as well. But to me, it's very interesting how badly the state wants to either not call this an alibi, cut off the time for bringing forth any other information of an alibi, and say that they're prejudiced for what's going on with these delays. As the Idaho Court of Appeals noted in State versus Juarez, the state has a legitimate interest in obtaining timely and complete discovery responses from the defendant. There hasn't been a lot of motions to compel the defense to turn things over, right? But the alibi is one of them. The state respectfully submits that we essentially remain in the same position as in July and August of 2023, and that, like Juarez, we don't know how this is an alibi at all. As the state further noted in its July 27, 2023 motion to compel notice of defense of alibi, or alternatively to bar certain evidence, the United States Supreme Court has observed in Taylor v. Illinois the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. Absolutely. If they're hiding the ball and they don't bring it up till the 11th hour, then I think that's a circumstance where we might have a stricken alibi or a stricken witness or something like that. But I don't think that's what we have here. And I think basically the defense is just leaving the door open to anything new they find out, especially because the state still has not provided all the discovery. So if something comes out in the discovery to prove where he was, like the state has video footage or more cell phone information from the cell phone download than the defense has at this point, in the interest of justice, I kind of think that's fair game. I'm sure you guys will let me know if you disagree in the comments. But also, if the state has this locked and loaded, I don't know what they're so afraid of. If they've got all the witnesses, they've got the DNA evidence, they're locking it in, what could he possibly come up with or fabricate that they couldn't easily blow a hole through? Because that's the other way to look at this. Like if Kohberger says, haha, I have a video that proves I'm right here, and they can look at it and say, that's not even your car, dude. Now he's lost all credibility. The defense attorneys making that argument have lost all credibility. So sometimes a weak defense can lose you the case if it's easily disprovable by the state. Based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add to any purported claim of alibi and preclude testimony by anyone other than the defendant as to the defendant's absence from or presence at the scene of the homicide. So they don't want an expert to be able to testify that Kohberger's phone was pinging over here, or they can prove his car was over there. They want to preclude the defense from cross-examining the state's expert to say something like that. They want to preclude the defense from cross-examining a state expert from saying Kohberger wasn't there or he actually was over here. I don't know if they call Kohberger's dad. He could be like, no, I was actually with him. They should be able to ask that on cross. That's fair game. So to say that no other witness other than the defendant can testify to that, if they can get it with other information, especially stuff they've put in their alibi, their expert, their cell phone expert, potentially testifying to something that proves Kohberger's not there. Now, is it specific enough? Maybe the judge will say no. Maybe we need more. The cell phone plots at 4:01 that Kohberger was 3 hours away from their house. That would be better if it existed. And if it did exist, I assume we would have that from the defense. They haven't provided it. Obviously, the state should still be able to cross-examine their experts, the defense's cell phone experts, to agree that his cell phone was not reporting from those times. Now, can they say with whatever their standard is, to a reasonable degree of forensic or, cell phone expert or electronic certainty or probability that he was in those rural areas and not at the house? Probably not. So that'll be interesting, but it just seems like It's weird to me how much the state has fought this, knowing that if some huge piece of evidence comes forward in the future, the judge is not just going to be like, defense, you can't argue it. I mean, we saw during the Murdaugh case, the data stuff from his GMC just came in during trial, and it was a huge part of the trial. So it's interesting. It's interesting. Sometimes it's like the difference between law school and what happens in the real world. Sometimes the perfect world, everybody following the statutes and all the evidence and discovery turned over like it should and everybody coming forward like they should, doesn't always happen in real life. And then we got to deal with it. But the interest of justice, the public policy, protecting people's rights, especially the criminal defendant, is going to be at the forefront of the judge's mind. I can't wait to read the comments on this one again to hear what you guys think about this. Thanks for joining me. Don't forget to hit the like button and subscribe to our page if you haven't already. That's all we got. Till next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.